Okay, thank you very much, Maria. It's been great to hear from you. Very much.
Right, well, I say thank you to the organisers for asking me to join you, and I see that I've got a very sophisticated audience in front of me this afternoon, because you're actually going into arbitration in great detail. And may I just ask then for a show of hands of those who have actually been involved in an arbitration, an institutional or an ad hoc arbitration, just to get a picture of, if I'm preaching to the converted, as they say, or whether I can actually add value by explaining something. Well, good show of hands. Thank you. Okay, well, I hope that you won't feel that, as we heard this morning, that in a submission that 30 pages on basics were presented to the arbitrator, and it seemed almost insulting to the arbitrator, and certainly something of a waste of time. I've drawn together a PowerPoint presentation to cover the title of this session, which is the role and importance of international commercial arbitration, which really could be a sort of historic piece rather than a practical piece. But nevertheless, I've put on my PowerPoint, now let me just see if I can operate this, the key elements of why arbitration is now really the most favoured form of dispute resolution in the business community. The arbitration is not a new means of resolving a dispute, and so way back in the previous century, since we're in the 21st century, but certainly in the 19th century, arbitration emerged as a means for people looking for their expert in that particular industry to decide on a dispute. And as globalization took over for the last 30 years, international arbitration has presented the solution of not going to the national court of one or other of the parties. So that, I think, really was the trigger at the beginnings of why arbitration as we know it now has taken such a firm foothold, to avoid the local jurisdiction where it was felt at the time that perhaps the rule of law was not what one party was used to, and the other party was somewhat suspect and wasn't familiar with the court system in the other jurisdiction. And so international arbitration provided the neutral forum. And the neutral venue has come to mean larger cities right across the globe. So whether it be, is the microphone still working? Yes. Whether it be Hong Kong, Singapore, or Zurich, Paris, or London, or indeed New York, these centres have developed and have come up with their own institutional rules. And the one thing that perhaps not every practitioner coming to a dispute for the first time realizes that the law of the seat, the law of the venue, is actually very important. And so the dispute resolution clause, when the contract is being negotiated, needs to take this into account. Should your neutral venue be somewhere like Switzerland, or can it be Hong Kong, or are you happy to sit in a less usual jurisdiction because the parties are sort of halfway, the point is halfway between the parties, like Vienna, for instance, where I come from. That is sort of seen as a neutral forum. But perhaps people don't realise that then Austrian law will take effect as far as the procedural side of how hearings are conducted, enforcement of the award at the stage if it is going to be enforced, challenges that may be made of arbitrators, and the recourse to the local courts for any particular aspect of which you might not be happy with. I've put it there as really the venue of arbitration is not just a matter of geography, but the legal seat, place of arbitration, which determines the legal framework for the arbitration. And I see that as the first thing that a lawyer in private practice should look into when suggesting where we sit, and also the costs that come with, for instance, sitting in London. So it's all very well for the LCIA to have produced a sort of row of arbitrations that now take place in London because they were in the early days of writing in the clause in Russian contracts. But is that really what the party wanted at the time? Did they want to go to London and have the expense of a dual system where you have to engage a barrister and you feel obliged to have a barrister because the other side's appointed a barrister as an arbitrator? And these are sort of nuances, if you like, of the seat, which a well-intentioned practitioner in private practice should draw their client's attention to when the underlying contract and the dispute resolution clause of the underlying contract is being negotiated. And I hope that those in private practice are fully aware that, you know, when you're advising the client, the disputes people have to be brought in not at the 11th hour just before the M&A documents are all going to be signed, but that somehow or other there's been a sufficient education within the law firm that says that there should be proper consideration given to the dispute resolution clause. Now, I've mentioned the LCIA, and I don't want to just damn the LCIA, but obviously there are arbitral institutions with a good reputation, and I personally, when I was in-house, always advised the inclusion of an ICC clause, because I rather like the way the ICC actually scrutinize awards. And doesn't have to be a seat in Paris. Often a client, a corporate entity will come and say, yes, we've heard of ICC, but we don't want to necessarily go to Paris. And that, again, you can have an arbitral institution without having the same venue. So these are things that may need to be explained to the corporate client. So that the venue and the institutional rules don't have to be the same. In Vienna, for instance, the institution allows the parties to choose their seat of arbitration, so they're completely free to do it and agree on it. And if they fail to agree and the clause somehow leaves out where the hearings will take place, or what will be considered the legal place, then Vienna is the seat of arbitration by default, by virtue of using the Vienna rules. I know Mark over there was telling me that he's working with my law firm DLA in the Gulf, and Henry Quinlan and I were on a panel a couple of weeks ago, and Henry was recounting an arbitration where they'd had a dispute before the arbitration about the seat. because the clause didn't include where the hearings were going to take place. And I say, well, Vienna rules provide for Vienna by default. That's not always the case. So please always advise your client carefully on where they want to have their arbitrations seated. The great plus of international arbitration and the award that is then comes out and rendered at the end of the process is the fact that there is enforcement now in 157 countries are now signatories to the New York Convention. This is by far the strongest enforcement regime that there exists in our legal world. Because as you heard earlier this morning, for instance, China does not have enforcement conventions, and reciprocal agreements do not exist with the United States. In Austria, there is no reciprocal agreement for enforcement of judgments from the US, and that is actually more commonplace than people realize. And that is why international arbitration really does give you the best tool if you're looking at enforcement and you're going to take your proceedings all the way through to an award. The signatories will vary in how much credence they will give to the requirements of the New York Convention. And there was, of course, quite a phase of notoriety in Russia where one of the grounds for an award not being enforced and the award being set aside was that it offended public policy. This can still happen, but interestingly enough, the world order has changed to the point where most countries will not use the public policy argument. And it is really understood that it would have to be quite a serious level of attacking the local mores of that country for an enforcement to be stayed or set aside because of public policy. The 5 grounds of the New York Convention still are there, and therefore what you have to be very aware of in the course of your proceedings, that an eye is always kept out for not in any way allowing the other party to find a loophole that might give them a chance to later challenge an award. So make sure that the procedures are followed properly. Make sure that the arbitrators appear to be impartial and that you haven't put in as an arbitrator somebody who's going to clearly look as though they're not independent. So for the party to support the process is something that I very much advocate. And then the award should then come out in a way that if you're a claimant, that you will be able to easily enforce and hopefully get the financial compensation that you had hoped for without too much of an issue as far as enforcement is concerned. Now, Jan raised in his presentation on arbitrations in the world of insurance disputes the confidentiality issue, and that is indeed a very strong plus for international arbitration. The court systems in most jurisdictions will not necessarily limit public knowledge of a dispute. The names of parties will get into the press. Lawyers have easy access to submissions in court records, and therefore arbitration really does give an edge over having something run in a national court in this department. But a note to everyone in the room, though, is that it doesn't follow necessarily without you actually dealing with it in the arbitration agreement, in the underlying contract. It rather depends on the rules you use and the jurisdiction you are in. So the best way to ensure strict confidentiality is to agree it already in your underlying contract as part of the dispute resolution clause, that there will be confidentiality, both parties agree, and even sanctions for breach of confidentiality can be introduced, particularly relevant in pharmaceutical trademark disputes where IP is likely to be discussed in submissions, and you don't want that know-how getting out into the public arena. So I would advise that the arbitration agreement, the arbitration clause, have a specific entry on confidentiality. As I put up on the slide, the extent of confidentiality is dependent on the law of the seat and the institutional rules applicable to the arbitration. And in fact, for instance, if you have a WIPO arbitration, you would have that in automatically, but you will not necessarily have it in other rules. Now, the great thing about arbitration used to be the procedural flexibility, which meant that you could more or less determine how much evidence you wanted, who you wanted, how long you wanted it to take, if you wanted it expedited, if you wanted to have a longer phase over something in particular, how many experts you wanted. And so that's the flexibility that continues to be there. But I think you probably heard from Mark yesterday that arbitration is no longer the cheap and fast means of dispute resolution that it used to think it could provide. The length of proceedings have become incredibly protracted, and I suppose in defense of the process, disputes have become more and more complex, with more and more projects being linked into one major project, and different aspects and different disputes arising, different issues, and it's no longer just because of someone sent a bill and they haven't paid. It's much more complicated than one used to think. So the idea, the procedural flexibility, when you write your dispute resolution clause, you want to leave in a bit of leeway, and I would advise against specific time limits in your arbitration clause, because that then really puts a lot of pressure on everybody. But these days, the institutions have come up with expedited procedures, and you can opt in or opt out, and so there are various ways of dealing with how to move your arbitration along quickly if speed is of the essence in your particular dispute. I've also mentioned here in my list document disclosure and the phase of document disclosure. I think it's got rather out of hand myself, because although Alan Redfern came up with the Redfern schedule and thought that this was going to help, lawyers in private practice have just used it as a means of extending the amount of money they make out of this particular phase. And so now you have 100-page Redfern schedules, and it doesn't necessarily help anyone, because I think that if the parties can agree to limit the number of documents, and arbitrators are brave enough to say, you know, let's only have the 25 documents that you're really going to rely on in the course of your proceedings, this is helpful. Obviously, it's a case-by-case assessment, and construction arbitrations can have just thousands and thousands of documents, and there are other fields, sectors that also have huge documents that you would just have a, you know, sort of 200 bills of lading that you just have to add on to prove that you have actually done this. But so I'm not saying that, you know, we limit it to 25 every time, but I'm just trying to make the point that there is flexibility in the process to look at the case you've got and say, where do we really need to prove something, and what documents do we really need to have here, and then take a very realistic, pragmatic approach, because as the question was raised earlier, are the arbitrators going to read it all? And you don't want to just drown them in documents that are not necessarily relevant. So it's really common sense. I don't know how you would define that, perhaps, because perhaps the respondent party is determined to slow down the process. But nevertheless, if you've got parties that are being practical and understanding that the costs will just escalate and go out of hand by virtue of having a US-style disclosure, and discovery processes that may not actually lead anywhere, I do think that on a case-by-case basis, do very carefully consider what documents and the document disclosure phase is going to entail. And the last point on my slide refers to bifurcation of proceedings. Again, on a case-by-case basis, but actually I've come across disputes where it's very helpful to just pull out one issue first of all and have a partial award on that particular area of dispute, and it then helps to sort of clear the air and where you're going, and what becomes relevant for the rest of the proceedings. And so again, flexibility. Look at your own particular dispute, what issues need to be resolved as a matter of priority, and then ask for bifurcation, if possible, agree it with the other side, and get the arbitrators to see the importance of it. Now, the role and importance of international commercial arbitration, which is the topic, has been challenged in recent years because the costs and the time are no longer what people thought they ought to be. And costs have escalated, and arbitration really is a very expensive process. I've tried to explain this to my clients now. If they're new to an international arbitration, they tend to think that it's going to be a quick and easy process. It is not. And I think one of the great challenges that those of us in private practice have is to explain this properly to our client. We heard how anger and the desire for revenge motivates people, and clearly in those early meetings when either you've just received a request for arbitration and you're at the receiving end and you're absolutely furious, there I can see that the client is not going to say, well, oh, it's going to cost that much, is it? Maybe we should pay up. But certainly help people to understand that, yes, take it to the next step, put in a very strong defense response, and use that as leverage. I really advocate this most sincerely, coming from an in-house perspective where I was prior to returning to private practice, to understand how strategic one has to be when resolving a dispute, and to use the leverage you gain by saying, well, we're going to fight, but we're ready to negotiate, and to use that properly. And I would very hopefully the in-house people work very closely with their outside counsel to help them to understand where the pressure points are, and that vice versa, that outside advisors say, right, now you've hit them with a ton of bricks, go in and try and negotiate a settlement. I don't know, personally, I haven't seen mediation combined with arbitration, and I don't know how much this is going to become a new way of resolving disputes. The idea of taking something off to be mediated and then coming back is still in my region of practice. So the Central Eastern Europe, Russia and Ukraine part of the world, still very, very new, and not something that people look upon with any comfort, and are still wary. But I think that is the direction we should be going, in the sense of combining the ability of a mediator or two mediators because in Austria, interestingly enough, they work together. You have co-mediators. You now have a co-mediator scheme attached to the commercial court in Austria, and it's relatively new, but it's taken off. It's being used, and I can see that tentative steps have already been taken, and so that the importance of international arbitration will probably mean that mediation, if it can be brought in under that umbrella, may succeed and suddenly make a mark in reducing the length and the costs. How to further reduce time and costs in arbitration? I've said you can decide to limit or abstain from document production on a case-by-case basis. Choose expedited procedures for smaller claims, and you probably all know that the ICC has just introduced its rule that came into effect on the 1st of March of this year, so that a sole arbitrator will be appointed in a claim of less than 2 million. And the previous tendency to have 3 arbitrators sitting as a panel seems to have sort of peaked, and I think we're reverting to more sole arbitrators being appointed. Certainly the institutions see that as a plus, and if there is really not a resistance from the parties, they are more likely to appoint a sole arbitrator, with the advantage of that being quicker, because it's only one person having to make up their mind as opposed to 3 people having to make up their minds. And then the other somewhat controversial issue, when you have a panel of 3 arbitrators, of when the wingmen have been appointed by the parties and feel a sort of conflict because they feel a need, even though they are impartial and are independent, but nevertheless feel a need to go into the arguments of the party that appointed them. And then you get a sort of hodgepodge award where everybody's trying to put together everybody's views, and you don't necessarily have a proper flowing, logical award which is very strong and clear in its final decision. Now, I used to be the advocate of a sole arbitrator when I was appointed by the ICC on a number of occasions, and I couldn't understand why people objected to having a sole arbitrator appointed by the institution. But when I went in-house, and suddenly I felt I needed a little bit more control over who was going to be the arbitrator, I was very, very much a person who fought Jan Paulsen and his idea that the institution should appoint all 3 arbitrators. And I would stand up at conferences and say, no, I'm the party. It's my party. I shall decide how you run this arbitration. And clearly wanted somebody who I felt was an expert in the industry and who would look at the documents. I was quite concerned, and I don't think it's necessarily a myth that arbitrators are not necessarily on top of the documents, and they get, sort of complete blitzed out by documents, and sometimes will overlook what's been presented as arguments. And so I always felt I wanted to have somebody I trusted would look at the submissions that we had put in. So that was why I was a strong advocate of the party-appointed arbitrator. As things become more complicated in our world and challenges are the order of the day as far as arbitrators are concerned, I now take the view that an institutionally appointed arbitrator is not a bad thing after all. Because why would the party challenge? The institution has appointed that person. That person is, with the best of their conscience, I'm sure, out there to do a good job of being impartial and independent. And so I would say to my audience here, do not be afraid of institutionally appointed arbitrators. Check them out. Make sure their CVs don't show any bias in one particular way or another. But nevertheless, trust in human nature of arbitrators are out there trying to do a good thing. They're not there to screw one party or the other. So that is my summary, I think, of making sure that you have a shorter process, a process that gets you to where you want it to be, whether it be just simply leverage to achieve settlement, or whether you actually go all the way to an award because your party feels they want to have their rights in black and white. But nevertheless, a process that doesn't lose its credibility and doesn't lose the validity that it has provided now as being the good forum for where to go if you have a problem which you cannot resolve out of court.
Thank you very much, Pri.
Thank you.
Thank you very much. Very well put. I have a question about the documentation, which I have unfortunately incurred some problems with. I mean, that there is a free flow of documentation coming in during the quite far into the process, and that the arbitrators are a bit weak on so say putting down the foot and trying to control the documentation. I don't know what your opinion is on that, but I mean it's quite disturbing when you're sitting and having so say that flow of new facts coming in and new documentation, which.
Yes, I completely agree with you. From back in private practice, from that perspective, you think, well, the arbitrators really aren't getting a grip of things. I suppose we have a problem here in how you regulate this area, and it's just sort of snowballed suddenly over the last few years, and there used to be a movement against having too much in the way of soft law and regulating arbitration, but I think there's probably a need for some soft law here, and that perhaps the IBA will take a view and produce a guideline. The IBA guidelines on production of evidence used to be the what everybody looked to, but that's now been hijacked somewhat, and people throw in all sorts of documents at very late in proceedings, and it's difficult unless you've got a very strong tribunal or a very strong arbitrator, or you have the backing of an institution, and that's where I think the institutions will have to take a firmer role, and this I see as something that will evolve and needs to be regulated.
Carrying on that point, how do you see it being regulated? In my experience, kind of the disclosure process and the pleading process is so far in advance of the hearing, the tribunal members don't have the time to read into it at that stage, and it's very much kind of prima facie decision making, or just if you establish the bare minimum, you can get things in or out. And tribunal members don't want to make decisions without having read the evidence, but they haven't got the time to read the evidence until a week or two before the hearing.
Yes, obviously, if I knew the answer of how, I would have told you. But I believe that it has to be a combination of understanding that there's a huge sort of production phase where both parties look at each other's documents, and then that you limit bundles. So that the arbitrators, you just decide that the arbitrators are going to only look at these documents. And the production phase, there has to be a cut-off, and only very exceptionally can you sort of introduce new documents. How it's actually managed, I can see that production of documents happens in a phase fairly early on, hopefully, and then you have to have a sort of interim period where everybody goes away and looks at it all, but really not so much the arbitrators looking at it as the parties looking at it, but the arbitrators setting a very strict date of that's it, no more, and then the parties between themselves agreeing on how to move, the next sort of the documents that are going to be produced to the tribunal. But I say I haven't really got an answer off pat. I don't know, but I'll put the question back to you, Mark.
I have no idea. I've tried many times.
You've tried many times. Yes. I mean, if you have a strong tribunal who say to the parties, now this is ridiculous, or a strong sole arbitrator for that matter, because I've had a strong sole arbitrator who said, no, this is it. We're not going completely off on tangents all over the place. Are these documents relevant? No. And if you've got somebody who can really take control of the process and has the respect of the parties, I think the parties would themselves then come to sense and see that we're not actually doing ourselves any favours by just having endless document production.
In my experience, what they do is they wait until closings, and then if there's too many documents, they ask for memorial type closings where, in effect, you have to then signpost them through the bundles. So at the early stage, and with even kind of pre-hearing, when the bundles are too big, they just say, well, you're going to have to there's too much on file, you're going to have to give us memorial closings where part of that has to be a reference point to each document.
Right. Now, I mean, it's difficult. Sitting as an arbitrator myself, it is actually, you're doing your best, and it's actually really daunting when, a truckload arrives, and you think, oh my God. So it's balancing the arbitrators' need to have time to read all these documents and the need for the party to feel it's properly presented its case. And if the party feels, no, we've got to have these documents in, it's very difficult for arbitrators to then say, well, no, we're not having those documents, because, of course, that is a ground for challenging the award. And so arbitrators tread a very fine line. And I firmly believe that the sooner these issues come out, the better. So it's a question of having it very much up front in the early part of the dispute of the process, and hopefully building up sufficient rapport with the tribunal that the arbitrators then can hold it in some, hold the reins fairly tightly.
Are you saying it's not possible from a rule point of view to place a limit in terms of number? Because I see this as a problem. If we are constantly complaining about the length of time arbitration proceedings are now consuming to such a degree that it's no longer too different from the protracted nature of litigation. I see this as a significant issue that should be dealt with and not left entirely to...
I completely agree with you. I see that as, the sort of death of international arbitration, if you like, because it takes away everything that was said was the positive by putting this terrible negative where suddenly the process drowns in the documentation and then becomes the equivalent of US-style court litigation. This is where international arbitration has to really be wary and find a solution. And I say I think it has to come from the institutions, so that if you put an ICC clause, if the ICC itself can say, no, we only do it this way, and it's in the ICC arbitration clause, or you've taken, it's part of the ICC rules, that's how you would control it. I personally see it as coming from the institutions, as the policing of the process.
Can I ask you about ARB-Med, or ARB-Med-ARB? Two of the weak spots, the Achilles heels of mediation. The first is that the parties can't be completely assured of an outcome. And the second is that if they do have an outcome and a settlement, the problems of international enforcement. Both those weak points can actually be addressed by ARB-Med-ARB, so that if you open an arbitration and immediately refer it to a mediator, if the mediation fails, it goes back to arbitration, so that there's certainty in an outcome. If the mediation is successful, it's referred back to the arbitrator for an award, which then becomes enforceable under the international rules. Seems to me to be an ideal answer for everyone. Indeed, and in fact, in Vienna, they've just done that. So the Vienna rules include this ARB-Med-ARB concept with exactly that, where your settlement reached through the mediation then has the same power and impact as an arbitral award enforceable under the New York Convention. So yes, I was very surprised to see that Austria had taken that step, and I think it's very sort of trailblazing. ARB-Med-ARB was discussed when I trained in the UK,
in the early 2000s, and Austria introduced a mediation act in 2003 or 2004. So we heard earlier about in Italy and Belgium. And when I qualified as a mediator in Austria, they were all a bit skeptical as to whether an arbitrator could be a mediator, and they absolutely had this sort of thing of two very different routes that you go along. But because I've trained as a mediator, I do see the need to introduce that aspect into the arbitration process. And I'm absolutely delighted that one institution has recognized exactly what you've just said there, Paul. Bear it in mind if you have a client. You can do it informally, obviously. So if you're under a set of rules, you just simply say, well, we're staying these proceedings pending a mediation, and then come back to the arbitral tribunal with the settlement agreement and ask them to consolidate it into a consent award. Completely agree.
This is a curious question. Having been an arbitrator in a number of cases, what is the minimum preparation that an arbitrator like you would do? This is really a curious question on the standpoint of a practitioner. Having submitted so much before the date of the hearing, loads and loads of documents, maybe it's a complex case, what is the minimum preparation in the same manner as we prepare? On our side, what is the minimum preparation given by an arbitrator? This is just a very curious question.
How long is a piece of string? No. Well, obviously it depends. And sometimes a case has had practitioners who are very used to arbitration and know to put together very, very succinct pleadings, or they have good pleadings with good summaries. And so you've been reading your pleadings all along, and you're actually completely on top of the case. That's certainly been my goal, and like to think that that's how I conduct myself when I'm sitting as an arbitrator. If you've got, as I said, this one particular case that comes to mind where the truckloads came in Paris, and I was sort of gone, oh my God, then you probably need to submerge yourself, and I definitely submerge myself for several days. There's no way you can escape that. You have to just, it's like preparing for an examination, and the longer you have, my daughter went off to sit the New York bar, and I don't know how many of you know that there's something called Barbary, which prepares you, and you have to do 6 weeks, and you have to do 6 weeks intensive. Now, she thought it was going to be, a walk in the park, and she didn't pass the first time. And I always think that that is somewhat something that arbitrators should think about too, because you need to submerge yourself totally in your documents, and you really cannot allow for other distractions to be on top of the case when you're there on the hearing day. So that's my view.
Nice to hear.
Excuse me. Based on your experience, what are the challenges in respect of recognition and enforcement of arbitral awards in third world countries, if you have an experience, no? And what practical things can be done about it?
I hesitate to use the phrase third world. As I said,
Emerging. Okay.
I haven't really enforced awards out of my particular region. So I say I'm a practitioner based in Vienna, and I speak Russian, and as a result developed a practice that very much was Russian orientated. I then headed as general counsel an industrial group owned by a Ukrainian oligarch. And so my areas of, or the countries that I've looked at are very much at the sort of the Wild West, if you like, of where I've been, have been the periphery of Central Eastern Europe and Russia. I was able to enforce an award in Russia in 2007 or 2008, which was at a time when it was considered quite difficult to enforce in Russia. That was when I was in private practice. The different regions of a place like, Russia is a continent in its own right. And so if you were going to try and enforce an award in somewhere in central, sort of the steppes or somewhere, I'm just trying to think, Omsk, Tomsk, something like that, you might still have a problem. But if you go to Moscow or St. Petersburg, I should think you'll be fine. I have had difficulties in enforcing an award in Romania. I've had difficulties in enforcing awards in other Central European countries which were very particular about numbers, getting addresses right, this sort of formalities which I fear are the heritage of the Austro-Hungarian Empire rather than communism. But they can be very pedantic bureaucrats. So I think the advice I give is make jolly sure your award is looked at 1,000 times and scrutinized even when it comes from the ICC. Read it again, that even, even if it's signed and there's something in there that might give rise to people querying it, send it back and get an amendment done to it and just have it absolutely 100% watertight whenever you go to enforce. I can't speak, I've never tried to enforce an award in Africa or Asia, so I really can't speak for those jurisdictions, I'm afraid.
The reason I asked that was, I think yesterday, some question about the arbitral awards as a quick way of resolving things, no? And I think enforcement is one aspect of it that contributes to the delay, no, in getting what you want under the arbitral award, no? In the Philippines, for example, although things are changing, judges tended to revisit the issues
Yes.
that have been
Yes.
decided upon by
Yes.
the arbitrators.
Yes.
And we were telling them that no, Your Honors,
Yes.
you can, the grounds for review
Yes.
are very limited, but sometimes they say it's public policy and so on and so forth. No, I know
Yes.
that there is that New York Convention.
Yes.
There are court cases that the public policy defense should not be taken into a parochial view.
Yes.
But I think there are realities on the ground.
Well, one always talks about arbitration-friendly jurisdictions and whether the courts will actually accept this is an award that has already gone into the merits of the case and it's not for us to open it all up again. And there are other jurisdictions where they still feel that they want to have a little bit of a piece of the pie. The London courts will do this, so it has nothing to do with third world, unless you think of the UK as third world now. But you can have judges who want to be involved in the decision-making process, and therefore will try and open it up. And obviously, looking to where you enforce an award, you will look into whether the courts will interfere or won't. But sometimes your hands are tied, and that's the place you're going to go and enforce because that's where the assets are. So there's no easy answer, I'm afraid.
Thank you very much, Maria Jan. It was two really brilliant presentations. I think it was a great closure of this fantastic event.